Good evening, everyone. Welcome to Asala's Classroom Talks, where we mentor future lawyers, we foster critical thinking, and simplify the law. Joining us today is a distinguished expert in fighting corruption in Kenya, and this is none other than Ms. Grace Maina. And Ms. Grace is a senior attorney with the Ethics and Anti-Corruption Commission of Kenya, which we shall be referring to as the EACC. She comes to us with immense, experience and wisdom, having engaged in very complex fights and legal matters concerning fighting corruption and tracing stolen money through money laundering and other ways that these are carried out. So we are most honored, Grace, to have you with us tonight, and we really look forward to this session. And perhaps I will pass the baton to you just for a few introductory remarks, then we get into the conversation.
All right. Thank you so much, Dr. Sala, and good evening. As you have heard, my name is Grace Maina. I work with the Ethics and Anti-Corruption Commission as a senior attorney in the Asset Recovery and Civil Litigation Department. I also am the head of the Mutual Legal Assistance Unit. And so I am so happy to be here this evening. Thank you, Dr. Sala, for hosting me. And I look forward to very good deliberations tonight. Thank you.
Yeah, thank you very much, Grace. And we also really are looking forward just to hear from you and, to have you share your experience and to help us also appreciate the magnitude of this problem that is called corruption, which really has relinquished the vulnerable population to the marginal lines in our community. So just to set the stage, I would like us to listen to the words of our former Prime Minister, the late Raila Odinga. And though he puts this in a hilarious way, I would like us to get the message and the meaning that comes with it. So over to you.
Your Excellency, let me tell you a story. And I was told when I was Minister for Roads and Public Works in my other early incarnation. This is a minister from Nigeria for roads and public works who went on a tour to Malaysia. There, on invitation. So he was taken by his host, taken around the country, shown the highways that they have constructed in Malaysia. And then in the evening, he was treated to dinner at the residence of that minister. There, he found a nice mansion, a swimming pool, and nice sofa sets, and dinner sets. So at dinner, so he asked his host, how did you manage this house? The host took him to the balcony and showed him, look yonder. Do you see that highway there? Yes. 10% here. Two years later, it was the turn of the Malaysian to pay a return visit. When he went to Nigeria, he was taken around the roads. You saw roads were potholed, some of them untarmacked, and very poor condition, very poor state of affairs. In the evening, he was taken to dinner, and he found a palatial mansion, Olympic-sized swimming pool. The sofa sets were imported from Britain. Most of the chinaware were golden. So he asked his host, how do you achieve all this? He took him to the balcony. And so, do you see that highway there? The Malaysian could see nothing. He was told 100% here.
Yeah, though put in a hilarious way, we see the gloomy picture that comes with corruption. And now, with this kind of background, I know it does not talk about Kenya, but Kenya is not excluded in this. Let us now just get into our discussion for this evening, Ms. Grace. And now I would like to turn to you, with a few questions just to try and understand how you deal with, tracing money that has been lost through corruption and money laundering. And to begin us off, kindly, if you can just help us understand what is the mandate of the Ethics and Anti-Corruption Commission, and how far does the law allow you to trace and recover stolen public money?
Now, EACC is a statutory body. It is established under Section 3 of the EACC Act. And this act was enacted pursuant to Article 79 of the Constitution. And so the mandate of the Commission is to combat and prevent corruption. This is done through law enforcement. It is done through prevention. We also do education, and we promote the standards of integrity and ethics. So basically, that is the mandate of the Commission. At Section 11 of the EACC Act, we have functions that are listed there. These are the functions that the Commission, these are the core functions of the Commission, in addition to the functions that are listed under Article 252 of the Constitution in respect to independent commissions, because EACC is also an independent commission. So specifically what I would want us to focus on this evening is Section 11(1)(c), where EACC receives complaints from the public, and EACC can also start investigation on its own motion, like on its own volition. So when we go to Section 11(1)(d), it states that after investigations by the EACC have been conducted and completed, what EACC normally does, we forward our investigations to the DPP, who is the prosecutor in Kenya generally. And in this report, we recommend to the DPP prosecution or any other, we make any other recommendation that, the investigations have found. And so let me expand on this point. We have seen in the previous years where defense counsels would go to court and make a prayer that EACC to release its reports to an individual or a specific person. Yeah. But the law is very clear that the only person who our investigation report is supposed to go to is the DPP for purposes of prosecution. Okay. And so we do not share this report with any other person.
Yes. Okay, and now that you mentioned the ODPP, Grace, what is the relationship between the EACC and the ODPP? Because in some instances, we see the EACC conducting investigations and trying to trace stolen money,
Yes.
yet the ODPP on the other side, we see a stall in the prosecution of these cases. What is your relationship between the two institutions?
Dr. Sala, the EACC and the DPP work very, very closely together. And this is because EACC does not have prosecutorial powers. So what the EACC is mandated to do is investigate and recommend charges or and make recommendations to the DPP. And so once we forward our recommendations to the DPP is also an independent institution. So based on what the review of the file will give them, that is how they move. So we cannot twist them to do what we think they should do. So in their independence, they make their own decisions on whether to charge or whether to close the file or whether to return the file to the EACC for purposes of further investigations.
Okay. And Grace, are there instances where you proceed with tracing and recovering money when there has been no charge from the ODPP, despite you having forwarded the files to the ODPP?
Yes, Dr. Sala, that is actually what we do. Section 11(1)(j) of the EACC Act, it mandates the Commission to institute and conduct proceedings in court for recovery of public funds, recovery of public assets, freezing and confiscation of proceeds of crime, and also payment of compensation where there are victims that are involved. Therefore, the mandate to institute civil proceedings in court does not involve the DPP in any way. So once we have completed a file and the criminal file goes to the DPP, a counterpart file is forwarded to the tracing team for purposes of tracing the proceeds of crime. And once that file is complete, then we move to the civil court for purposes of recovery or any other suitable remedy that we deem fit. So we do not involve the DPP on the civil aspect of the matter. Yes.
Yeah, now that you talk about the civil process of recovering the assets, and we know that the standard of proof in civil cases is on a balance of probability as opposed to the criminal case, which is beyond reasonable doubt. So when we subject the recovery process to a balance of probability, don't you think we are compromising the effectiveness of the recovery process?
No, I don't think so. This is because even in Section 193A of the Criminal Procedure Code, it allows criminal proceedings to run parallel to civil proceedings. So there is nothing that is stopping EACC from pursuing both at the same time. And in a conviction-based forfeiture approach, it is the most preferred as we are moving as we are progressing also in jurisprudence. We find that it is a more suitable approach when we are talking of matters corruption, because when we talk about the balance of probability, when we talk about the burden of proof, for example, some cases have this evidence, yes, but the evidence is not strong enough to support the evidentiary burden of beyond reasonable doubt. And so, but this evidence that we have can actually sustain a civil suit on a balance of probability. So we are actively moving towards asset recovery as a way of deterrence in matters corruption. I cannot say as opposed to criminal matter, because of course we cannot downplay the criminal proceedings, but we are active as a commission. We are actively focusing on asset recovery as a means of deterrence in corruption matters.
Yeah, yes. and you do mention the burden of proof, and we see that in civil recovery processes, the burden of proof, in criminal cases, it's normally on the ODPP, the state, to prove beyond reasonable doubt. But then in
Yes.
the civil process of asset recovery, the burden shifts to the suspect, to explain the source of their wealth. And one can easily wonder whether this really is consistent with the constitutional principle of fair trial.
Let me talk about Section 55 of the ASECA. ASECA means Anti-Corruption and Economic Crimes Act. So Section 55 of the ASECA gives the EACC the mandate to to institute unexplained wealth proceedings. So this means that investigations are conducted to recover a disproportion of a person's wealth that is not explainable. So what I mean is a report is made of a public officer who is living beyond his means, for example. And we cannot pinpoint what this person, the criminal offense that this person is committing. But by virtue of having or amassing a lot of wealth, then it means that the EACC will conduct investigations that seek to uncover where he's getting all this wealth from. And therefore, when we are conducting the investigations, we give them an opportunity, the suspects, we give them an opportunity to explain to the commission where exactly or what the source of these assets are. And if the explanation is not satisfactory, then at that point we move to court. Section 55 of the ASECA also mandates the EACC to discharge that burden on a balance of probability that actually these assets are suspected to be acquired through a suspicious conduct, And once the court determines that the EACC has discharged that burden, then the burden now shifts to the defendant, because who else knows where you bought this property or how you acquired this property? It is the suspect or the defendant who knows. So in as much as EACC may have an idea of where this man is coming from, it is the defendant himself who exactly knows where the property came from. And therefore, the court, in trying to determine this matter conclusively, will shift that burden to the person so that they can explain exactly where the money is coming from to amass this kind of wealth. So that is how the burden shifts to the defendants.
Okay, thank you for that clarification, Grace. And now when you talk of the EACC conducting investigations, I know you have to maybe acquire access to bank statements,
Yes.
money transfer records, financial transactions. How does EACC ensure that they have legally accessed this documentation without compromising, the right to privacy of the suspect?
All right. During investigations, the EACC has tools available to it so that the information that we get is legal. So at the very instance, we make applications. At the very instance, we engage the intelligence. So the intelligence is able to give us an indication of for example, which bank accounts to pursue or which properties to look into. And Intel also entails collaboration with other government agencies, for example, FRC. We also collaborate with the Lands Office, the NTSA, and but when it comes to obtaining evidence, we have to do it formally and legally. And so what the EACC does is we use tools like warrants to investigate bank accounts. We use warrants to search premises. We also do official letters to government institutions to give us information. And once we piece all this information together, now we prepare a report. Therefore, everything that EACC does is within the law. And we cannot do anything outside the law. So when you talk about rights to privacy in respect to property of a person, the Commission is very strict on confidentiality. And a matter that is live under investigations cannot be discussed. And so we cannot divulge any form of information to any person except for purposes of investigations. And so we normally are very sensitive to the information and the privacy that the information we get to satisfy the privacy requirements of the information obtained.
Okay.
I hope I've answered.
Yeah, thank you. Thank you. At least you've shared off some concerns, that were arising concerning how you access this documentation. And now let's look at how you trace the money, especially given that most of the individuals who get involved in corruption and these kinds of devices, want to hide this money in the names of their wives, their spouses, their children, relatives.
Yeah.
How do you get to investigate beyond the suspect, to look into the accounts of the spouse, the children, or other relatives who might have hidden the money?
Wow. The intention of corruption is to amass wealth. And therefore, people will do anything to get hold of this wealth and hide it. In respect to hiding wealth in other people's names or hiding wealth in companies, shell companies or whatever it is, there's the beneficial ownership aspect that we normally look into. And this is domiciled at the company's registry. So if it relates to a company, then we request for such kind of information in respect to specific companies, and we follow the money. So following the money means tracing. So money will always lead you to where the person who is benefiting is. And so if that tracing of money leads you to a specific company, and that company is registered in totally unrelated persons, we collaborate closely with the beneficial ownership service at the registrar of companies. And then we get the information and also, of course, conduct forensic investigations. In respect to close associates like spouses and children, we also collaborate with the Register of Persons to uncover the relationship between these people. We also collaborate with the Register of Marriages to get information on spouses. And so possibilities are endless. We normally do a very thorough job, and when I talk about forensic investigation, means we do not leave any stone untouched. We do a very thorough job in investigations. Yes.
Thank you. We truly appreciate the kind of job you do. We don't envy you for some of us, but we do appreciate the kind of job that you do. Now, you have mentioned some very difficult terminologies. I've heard of shell company, beneficial owner, What are these? Yeah.
A shell company is a business that is legally registered, but it has no significant assets. It has no employees or very minimal employees. It does not have any form of operations, and the business is also very minimal. So in short, these companies, in as much as they're legally registered in Kenya, they're mostly on paper. And so most people will amass wealth and send and disguise these proceeds of crime under shell companies just to hide their identity. And we see normally how lawyers are also collaborating with their clients to do this kind of thing. And so the suspects in this case register those properties in these kinds of shell companies just to disguise and to, of course, conduct money laundering activities. So in terms of beneficial ownership, what you have just said, Dr. Sala, that I might steal property, for example, and because I do not want the government to know that I am the one who has stolen the property, I register a company, and this company is not in my name. One of the directors in that company is not probably even closely related to me. Maybe it's your cousin, your relative, or whatever it is. But once we start the investigations, we request for documents at the BRS, the Business Registration Service. And this Business Registration Service keeps a records of all the companies and the directors and the shareholders. So it is from there now that we extract that kind of information. Mm-hmm. We also get this kind of information in bank records. We find that the same company will go and open an account in a commercial bank, and because they are not directors they are directors behind the scenes, it means that they will want to operate the account, yes, but not be on the forefront. So most of the time you'll find that they are signatories to withdrawing the money, but they are not on paper per se. So as I've said, the tracing of money is very detailed. It is very we do it very I can't even find the word. Yes, we are very thorough. We are very thorough. Yes.
Yeah. Okay, and sometimes, Grace, you find that stolen money is transferred across border, and even the nature of money laundering, many times it's transferred across border. And I'm just eager to hear from you. What are the kinds of collaborations you need at this stage to effectively, trace this money and recover it when it has gone across border? And what are some of the institutions you have to partner with in order to make this process effective?
Wow. I love this part of the law. When it comes to corruption has become very globalized. And we've also seen in the news how people steal money and take money in another country just to frustrate the investigations and, of course, engage in money laundering. So at the starting point, where we have established that there are some assets that have crossed the border to other jurisdictions, we engage informal networks. So by informal networks, I mean intelligence. We can engage police-to-police assistance, like, for example, the police of Kenya and the police of Uganda. We share information and we establish whatever it is that we want to establish. We use Interpol. We use regional networks like the ARIN. ARIN means Asset Recovery Interagency Network. There's one in East Africa. There's one in the Southern Africa. We also have a very vibrant network that is called the International Anti-Corruption Coordination Center. So this is a very vibrant international organization that really assists in tracing, in gathering information, in getting information, because mutual legal assistance does not encourage phishing. You cannot go to a country seeking to get information, but you yourself, you don't have the basics. So intelligence helps us to get the basics, even open source. Some countries, the registries are open. You can actually search something like land and get information from the internet. And so at the first instance, we engage formal networks. Formal networks may also include like peer-to-peer networks. Like, you have gone for a training, you have collected a contact, and somehow there's a property that you're following in their country, and you just open communication and you start your investigations. After you have gotten enough material to prepare a formal request, then at that point you sit down and prepare what we call a formal mutual legal assistance request. So this request is very formal, and this is the basis within which we obtain information legally from other jurisdictions. And so it is in form of a letter, because you are addressing the other jurisdiction formally, and in the same letter you are summarizing your case and seeking for help, specific help that you need. If you need written statements, that is what you say. We need written statements, we need bank statements, we need 1, 2, 3, 4, and that is how you get assisted. But it is not just a matter of waking up, drafting, and sending. No, there are channels. So here in Kenya, our central authority is the AG. And the enforcement agencies are called competent authorities. So as a competent authority, EACC prepares a mutual legal assistance request. We request the AG to send this request to a specific jurisdiction for purposes of assistance. So the AG will reach out to the central authority of that country through the Ministry of Foreign Affairs. And that is how the MLAs are transmitted. So that central authority of that other jurisdiction will now channel it to the rightful agency for purposes of conducting investigations. And the evidence comes back the same way. So you cannot just wake up and send the MLA request or receive the evidence directly. There's a channel, and that is called the chain of custody. When you go to court after you've gotten the material that you are waiting for, the court will want you to demonstrate the chain of custody. How has this evidence moved from that jurisdiction to Kenya? And if there's a break of chain of custody, then it is easy for the court to discard your evidence after you have gone through so much to get it. So the chain of custody is also very important. Something also that is very important is the translation. There are some countries that do not accept, mutual legal assistance requests in English. So you have to translate in their own language. So for example, we wanted some information from Poland, and we looked for a Polish translator in vain in Kenya. And so those are the challenges. Those are some of the challenges that we normally get. So a mutual legal assistance request is a very vital instrument in investigations. And more often than not, we have gotten positive results. I want to point you to the NCPB case, where I think it was John Waluke who was convicted. That conviction was largely because of the material we got from South Africa. We also prosecuted the civil case related to that criminal matter, and we were able to make some recoveries. We also facilitated the witnesses. Witnesses actually traveled from South Africa to Kenya to come and testify in our courts. So it is a very vital tool of investigations in this modern day. Yes.
Wow. Yeah. Interesting. Thank you very much for these kinds of insights, which many of us are learning from you tonight. Let's now look at effective investigations. And from what you're saying, your side of investigations becomes easier when there is documentation. For example, you can follow bank transactions. You can trace how the transactions were done. But I'm also thinking of a scenario where people engage in cash-based transaction.
Yes.
So someone comes with a lump sum. I've seen instances where someone is buying a 50 million house in cash. 20 million, 30 million in cash. There are also instances where, I know perhaps in Kenya it's illegal, but it's nonetheless still happening. Cryptocurrencies. People mining these currencies and engaging in business.
Yes.
How do you deal with this kind of complicated scenarios where it becomes really difficult for you to trace these illicit flows, and even the instances of offshore accounts?
All right. Maybe I can start with cash-based transactions. As we have already stated that money laundering is very complex, and especially when it comes to cash transactions, because there's no paper trail. And when you try to trace these assets, you hit a dead end, because at some point when the money reaches the bank, it is withdrawn in cash. So you don't even know who or where that money is going. But to bridge this gap, the Commission has intensified the unexplained wealth, proceedings and lifestyle audits. And so if somebody is withdrawing large sums of money in cash, probably that money is going somewhere. And so what we normally do is we conduct lifestyle audits of that person or even their close relatives, so that now we are telling them, your salary is 50,000. How come you can afford to buy a 50 million house in cash? Explain where the money is coming from. And so if they cannot explain, the court will definitely forfeit that asset. And so what the Commission has actively been doing lately is to intensify the lifestyle audits and the unexplained wealth matters, so that we curb the cash-based transactions, and especially in the country. When it comes to offshore accounts, under the Leadership and Integrity Act, the state officers and public officers who have offshore accounts are supposed to declare the accounts that they are holding and for what purpose. But unfortunately, there has not been a lot of buying in this nation, and the offshore accounts are not declared as much as we would want them to be declared. But as I have said earlier, we really engage or network with the foreign networks that we have made over the years. We have actively looked for such networks, so that at any given time when we have intel on offshore accounts that are siphoning money from Kenya, we are able to get information on those specific accounts. And so it is a continuous process. It is a process that you build by the day, by the year, it is very continuous. And the more you do it, the more networks you develop. And so very soon, the world will be a very small world in terms of money laundering and illicit financial flows.
Mm-hmm. And perhaps a comment on cryptocurrencies?
On cryptocurrencies, yes.
Mm-hmm.
On cryptocurrencies, what I can say about it is that the Commission is actively training its staff on cryptocurrencies. Because even when probably you search the premises of a person and get a password, most of the time as a lay person, you would not know that this is a password to a cryptocurrency. And therefore, what the Commission has been doing lately is to actively train on cryptocurrencies. And we also, we saw the other day the new law that has come in play, in terms of virtual assets. And so we have not had a lot of cases dealing with cryptocurrencies, but this is the time that we are taking these cases up. Yeah, even as we actively train the officers. And maybe something else to add is that the Commission the Commission can always onboard professionals. So if we find that there's a matter that has a lot of cryptocurrencies or a lot of money hidden in crypto, nothing stops the Commission from recruiting or onboarding a professional in that area.
Yeah, but I understand your dilemma, because again, if you don't have the know-how, it becomes difficult to know even how much someone has kept in cryptos. And so this is really a gap that we hope with time the Commission will be able to seal. And I'm glad that you have ongoing trainings. Hopefully, given a few maybe months or years, it won't be a problem anymore. And so if we may just move to the way you recover assets. We've seen instances where the Commission frees people's account, or or you want to preserve the property for those properties that have been implicated in crime. How does the Commission do this in a legal way? Because many times we just see it in our news that this person's property has been frozen for this suspicion. But then how do you go about freezing someone's property? Especially if we look at the potential of this kind of activity affecting the rights of the suspect.
Okay. Freezing someone's property for purposes of investigations. We have two stages. There's a preliminary stage where you have just started your investigations and you have gotten information that probably there's an active account that is probably transacting in proceeds of crime. And so Section 56 of the ASECA comes into play. Now, this section allows EACC to apply for preservation orders for 6 months pending completion of the investigations. So we go to court, make a formal application, ask the court to grant us 6 months, to grant us preservation orders as against a certain probably account or property pending investigations. So this application is ex parte. So based on the evidence that EACC has presented to the court, the judge now makes a decision. And most of the times, the judge will give us 6 months because at that time, we are just starting the investigations. Okay. So after 6 months, or even before the 6 months lapse, for example, when we serve the order, the defendant or the respondent has 15 days to seek a discharge or variation of those orders. So it is at this point that the suspect is invited to give his side of the story, and the court will take into consideration whatever material that the person has brought on board. And after the 6 months, after the lapse of 6 months, if the EACC has not completed its investigations, the law allows us to seek for an extension. So at this point, the court will depending on how much time you need, the court will always decide and make a determination on how much longer will EACC continue to investigate. So after the investigations are complete, then we institute civil proceedings. So contemporaneously, we file an injunction application. So this injunction application is now for purposes of freezing the property that was already frozen through the preservation application, now pending hearing and determination of the suit. So as you can see, everything that we do is in the law. It is not practice that is far-fetched or platform. No, it is anchored in the law, and it is very legal. And so the defendant is invited, even by the court, to come and make submissions in respect to either the preliminary stage of freezing or at the point of the injunction. Yes.
Thank you for educating us on how you do this. We are all learning, and we are glad that we can learn from you. And now let's assume that you have recovered this money. You have tracked it and you have recovered it. What do you do to make sure that this recovered stolen money benefits the public and it does not disappear again?
Wow, that is an interesting question. I'll still go back to the Anti-Corruption and Economic Crimes Act. So Section 56, capital C of that act mandates the EACC to pay funds recovered into the consolidated fund. So, of course, the consolidated fund is a fund that is managed by the government, by the national government, of course, pursuant to Article 206 of the Constitution. And so, if, for example, we have recovered, the court has forfeited property that is private, like when it comes to unexplained wealth proceedings. You see, these properties are not public in nature; they are private properties. And so, what normally happens is that we ask the court to give us an order for purposes of disposing these properties by public auction, so that now, once we receive the money, we deposit that money into the consolidated fund. And after the money is deposited in the consolidated fund, of course, now the Public Finance Management Act comes to play. In terms of landed properties, we have recovered a title that belonged to a public institution, for example, and somebody had converted that interest into their own personal interest. So what normally happens is that the law, the same section 56C of the ASECA, mandates us to register that property in the name of the permanent secretary, treasury. Nowadays they're called principal secretaries, treasury, on behalf of that institution that we have recovered property. Yeah, we have recovered their property, so that now nobody else will come and, and hijack the process of registration. But there are instances where the property is already in use by a specific public institution, for example, a university. So the university, we will cancel the illegal title and register the title, the title in the name of the university. So that is normally.
Okay, thank you very much, Grace, for these insights that you're giving us tonight. And perhaps as we come to a conclusion of this first section of our conversation tonight, I would just like to hear from you. What is your take if you are to be asked whether asset recovery is an effective tool of fighting corruption and money laundering as opposed to criminal prosecutions?
Okay. There's an interesting judgment that we obtained from Justice Onyeko in 2019, and one of his determinations was that maybe I can read verbatim. The key objective in legislating Anti-Corruption and Economic Crimes Act was informed from the viewpoint that some actors in the criminal world are smart in the manner in which they carry out their criminal activities, leaving no trail of evidence to secure a conviction in the criminal case. And therefore, once the Commission establishes reasonable ground to suspect that the property in one's possession cannot be explained, then the burden will always shift to the possessor of the property. And so in matters anti-corruption, we are actively moving to an era where people are stealing smart. And therefore, we also have to devise ways of being smarter so that the focus shifts from the person to the asset. And in this case, it is the possessor of the asset to tell us where or the source of money that they used to get this property. And therefore, what I can say is that, yes, civil proceedings in anti-corruption matters have exceedingly borne more fruit if you compare with the criminal proceedings. But again, we cannot downplay the role of the criminal proceedings, because to amass such kind of wealth, of course, there's a criminal element. There's something that is happening that is illegal that this person is doing. And so in as much as the burden of proof is very high beyond reasonable doubt, it does not mean that that person will go scot-free if that burden is not satisfied. So that is why we fall back to the civil proceedings, where the burden of proof is a bit lower on a balance of probability, and the court will actually weigh what are the evidence that the ESCC has presented and the evidence that the defendant is presenting, and after consideration, of course, comes up with a decision. And we have increasingly seen forfeiture of properties that cannot be explained in numbers. So I think it is the best direction that it is a good decision that you've taken, even as a nation and as a commission, to look that direction.
Wow. Thank you very much, Grace. Like I said, I can't stop listening to your presentation and just learning more and more every minute. It's been very informative and insightful for anyone who wants really to understand how the EACC traces and recovers assets that are a proceed of crime, for instance. So thank you. We really appreciate, and perhaps I'll just turn to the comment section if there is any comment. Perhaps if you have a question, feel free to ask. If you have a comment, again, feel free to post in the chat. We have a few comments. First and foremost, we have a comment from Sheila Bahati, who says, grateful for another opportunity to learn. That's a mere comment. Then Anthony Odhiambo, good evening, councils. Great to be in the class and ready to learn. Then Mutuma John says, this is insightful. Yeah, I think we don't have many comments. It seems people are learning. This is a new area that many people have not really engaged with, and we don't really understand the insights of the EACC. And so we truly appreciate your presence and just the fact that you're willing to help us see the inside part of the EACC and the troubles that you go through to wriggle out and navigate the legal matters that arise in tracing and recovering stolen public money. So thank you very much, our guest for tonight. I will pass the baton again back to you for a few concluding remarks on your highs and lows in the moment of tracing public money and whatever else you'd like to conclude with. Over to you.
All right. Maybe I can also comment on the litigation side of the asset recovery civil matters. And in terms of delay, and once we are in court, we are subjected to the court's diary, even as EACC. And of course, we cannot bar the defendants or the respondents from filing or making any interlocutory applications in between. And therefore, in as much as the challenges are there, we are grateful to the judiciary for purposes of establishing the anti-corruption division of the High Court and also the Special Magistrates Court in the lower court. And so we have seen since 2015, we have increasingly seen a higher turnover of matters, of anti-corruption matters being decided and being concluded faster than before. And so that had been a challenge for so many years prior to 2015, but increasingly we are seeing a lot of turnover, and we are grateful. We are grateful. And in terms of resource constraints, of course, like any other government agency, resources are never enough. But as a commission, we have come up with prioritization mechanisms just to prioritize the high value matters or the matters with very high public interest. And of course, we also work very well with some partners, and we find ways in breaching the resource constraint challenge. In terms of fair administrative action and fair trial, Dr. Sala, you have mentioned a lot on fair trial and fair administrative actions. As I have explained, there is no step that we undertake in the investigation in the investigative process that does not involve the suspect or the defendant. So they are always called upon to record statements, to give us evidence, and it is from there that we conclude our investigations and maybe proceed to court. And therefore, there's no avenue of unconstitutionalism, if you know what I mean. Also, that coupled with the professionalism of the commission and also the nature of officers. Because even investigators are professionals, they're lawyers, they're accountants, forensic investigators, we have document examiners, we have a lot of professionals. And so Kenyans need not worry that EACC is people are not learned. No, we are not. We are we are professionals. We are professionals. In terms of the highs, one of the highs is the anti-corruption, of course, the division itself, because having a specialized court is very useful, because you see that the judges who are sitting in those courts actively engage in this practice. And so we get very quality judgments, and we also get a high turnover of our matters. It is different when we are presenting our matters to judges of other divisions, where they are not so conversant with the practice of the anti-corruption. And so those are some of the highs. We also have what you have just talked about, the collaborations, the agency collaborations, the mutual legal assistance, where you get evidence, like tangible evidence to take in court. Those are the real highs. The commission also has we have an academy, and this academy it's called the Kenya Ethics and Anti-Corruption Academy. This is where we train Kenyans on matters anti-corruption, ethics, and integrity. And so the commission is not just about investigations. We do other things also. We have actively trained public servants. We have actively trained members of the public. We have actively trained private citizens. We actively train. We also have the Kenya Leadership Integrity Forum, the CLIF. This is a platform, a collaborative forum of different sectors. We have the private sector, we have the government sector, and we also encourage citizen-driven initiatives against corruption. So here is where we engage a lot of people, the youth, the children, the school-going children, So ESCC is not just about investigations and arresting people. We also do so many other things, even to sensitize the public.
Yeah, thank you.
Yes.
Thank you very much. Whenever we hear of ESCC, we imagine arresting people, and then there was a time, you imagine setting up people for arrest and all that kind of thing. But we truly, truly appreciate the kind of work that you do. And, we just want to wish you the very best in all your endeavors. We know it's not an easy job, no mean feat for any Kenyan, especially given our context. But we honestly wish you the very best, and we look forward to a reformed Kenya, free of corruption, if there can be such a society.
Yeah, we shall achieve that dream one day. Thank you so much, Dr. Sala, for having me.
Thank you, and God bless you. God bless all our audience. Please feel free to subscribe so that we can be notified of more discussions in the future. Thank you, everyone. And